Dear friends, welcome. Today we are going to see another guidelines laid down by the Supreme Court of India regarding arrests, how the police can arrest people. In this case, this came out of the case Anish Kumar. This is Anish Kumar guidelines. Anish Kumar versus State of Bihar, 2014 case. What happened is, this is a case under Indian Penal Code 1860, section 498A, and Dowry Prohibition Act 1961, section 4, and the Code of Criminal Procedure, section 41, section 57, and 167, and Constitution of India, Article 22. Okay. Supreme Court gave these guidelines for the police to arrest a particular person, concerned person. This 498A is commonly known by the people, is filed by the police when there is a dispute between husband and wife. When the wife goes and lodges a complaint in the police station, this is there is an FIR filed, and the husband and the family of the husband, whole family of the husband are arrested. This happened normally before 2014, and after 2014, there came a change. Now that is what we are talking about now. What happened is, Supreme Court gave eight points in arresting a person. You should not immediately go and automatically arrest the persons like you did in the previous years. Then the complaint is given, immediately they will be arrested, and the case will be filed, and they will be put in the jail. All such will happen. And this judgment came, they could not do that. What is this all about? 8 points were given. First point, first point, all the state governments to instruct the police officers not to automatically arrest when a case under section 498A of IPC is registered, but to satisfy themselves about the necessity for arrest under the parameters laid down flowing from section 41 CRPC. So now we have to see whether all the points laid down by the Supreme Court of India are complied with before the arrest. First one, the state governments, all the state governments in India should instruct the police officers. State government should instruct the Director General of Police, and Director General of Police has to instruct all the officers under him, and all the officers under him should instruct the police stations, inspectors. Thereby they should be instructed about this. But in spite of this, these points, sometimes this also happens, maybe unaware or aware. This should be also stopped, and we have to know about all these things, then only it will help the public. All police officers provided with a checklist containing specified subclasses under section 41 1B2, and the police officer shall forward the checklist duly filed and furnish the reasons and materials which necessitated the arrest while forwarding or producing the accused before the magistrate for further detention. There should be a checklist with the police, and the police should produce the checklist before the magistrate when they go and produce the accused before the magistrate for detention, further detention. And fourth thing, the magistrate, while authorizing the further detention, should go through the checklist and peruse all the documents filed by the police, and then only record everything there, and then only he shall be pleased to give that detention order. And fifth one, if the police do not want to arrest the particular person, concerned person, they have to record why they don't want to arrest, and they have to forward that to the superintendent of police and the magistrate in writing why they are not inclined to arrest the particular person. Sixth point, notice of appearance in terms of section 41A of CRPC to be served on the accused within 2 weeks from the date of institution of the case. From the date of institution of the case, they go to send a notice to the accused asking him to come and come for inquiry. This is to be complied according to section 41A of CRPC. This is mandatory. They should follow. So summon is very important for the police to serve on the accused, and accused has to appear before the police, and the police should not arrest him. Instead, they have to inquire. This is important, and everything has to be recorded. And the time, this should also be done within 2 weeks time from the institution of the case, and if needed, maybe extended after obtaining permission from the superintendent of police or the commissioner of police. And then seventh point is important: failure to comply with all these directions, all 6 directions above said. If they fail to follow all these things, the police officers may be dealt via court, because Supreme Court has given these directions. If they don't follow all these things, contempt of court can be filed against them, and they can be punished through departmental action. So 2 things may be done: departmental action and the contempt of court can be filed against them. The same way, the magistrate will also be put into departmental action by the High Court, wherein under which he is working. If he gives order for detention without any perusal or without any recording the reasons for his order, all such. So now what we understand is 2 things are important in this. One is, police officers should not arrest automatically on being complained by the women. If anybody comes and complain to the police should not arrest a person immediately, automatically, as it happened earlier, before 2014. Police has to send a summon to the accused, and the accused has to appear before the police, and they have to inquire. Everything should be recorded. Everything should be recorded, and this has to happen within 2 weeks time from the institution of the case. And they have to, if they want extension, they have to get the extension from the superintendent of police. Permission of the superintendent of police, they can extend. With the permission of the superintendent of police, they can extend. Without which, they cannot. And magistrate also has to record everything. There should not be any automatical detention order or such. So now another third point which is important here is, this is not only applicable for all 498A cases, 498A of IPC cases, no. And it is not only applicable for Section 4 of Dowry Prohibition Act 1961, no. It is all applicable, these instructions, all 6 plus 2, 8 guidelines are applicable to all the cases where the punishment does not exceed 7 years or punishment does not exceed 7 years with fine. So all the cases where the punishment is only for 7 years or just below 7 years with or without fine are to be dealt like this. They have to inquire first. They have to first give the summon, not only inquiring, they have to give the summon, then inquiring, then they can go ahead with other things, not automatical arrest all such. This is given by the Supreme Court of India, and this case is known as Arnish Kumar case 2014, or Arnish Kumar guidelines given by the Supreme Court of India in 2014. You can see next video in the next time. Thank you.